Every city has that one spot, a creative pop-up, a fashion takeover, a cafe that was there one week and is gone the next. But what most people don't see is the legal side of those spaces. So the contracts, permissions, and promises that make the creative world spin. Because behind every perfectly fit activation or underground gallery, there is a landlord, a tenant, and a document that decides what happens when the lights go out. I'm Blessing Wakosha Park, and today we're diving into the realities of how creatives use commercial spaces, the good, the bad, and the legally questionable. Joining me today is property solicitor Anna Zandi, who's seen firsthand what happens when creative meets commercial reality. This episode is brought to you by Blessing at the Bar, a platform supporting aspiring and practicing lawyers through practical resources, courses, and productivity tools. Whether you're starting out or already in practice, Blessing at the Bar helps you stay organized, focused, and confident in your career. You can find out more at blessingatthebar.com. So thank you for joining me today, Anna.
I'm happy to be here. Thank you for having me.
I thought what we could open the conversation with is talking about the difference between a license and a lease, because it's something we definitely know. We deal with this on a daily basis. But how would you describe the key differences between the two terms?
It's a good question. And I think it's a question that's probably not spoken about as much as it should be in plain terms. But I would say a license is sort of like a personal occupancy. It's flexible, and whereas a lease has far more provisions in it. A lease essentially is the landlord giving the contract for occupancy over to the lessee. So for example, in a lease you have fixed terms, you have deposits, you will have far more covenants on both sides, so tenant and landlord covenants.
How would you describe a covenant to someone who maybe doesn't know what that word means?
That's a good one. Sort of like obligations.
Or a promise. Yes,
a promise, or an obligation that has to be fulfilled. So, for example, it could be a covenant to not do something or a covenant to do something. And that would lay out the responsibilities of each party in a lease. With a license, I think there is also, like I said, a bit more flexibility. Giving notice is easier.
So actually ending your occupancy under a license is a much more straightforward process than when it's a lease, isn't it?
Exactly, yes. It's far more straightforward, and that flexibility is there for the landlord, but also there for the occupant or the licensee. So I think for a license also what I see is that it's normally for a shorter term than lease. So a lease can go on for hundreds of years, really. But typically for a commercial lease, it can be anywhere between 30 years, maybe 30, 20 years. There might be a break clause negotiated for that as well. Whereas licenses tend to be for a shorter period of time. So perhaps for licenses, they might be more appropriate for maybe pop-ups.
Yeah, that's what I was thinking.
They might be more appropriate. So for example, we've got the Tala pop-up recently opened up, I think Regent Street, or somewhere around that part. So yeah, this is their first pop-up, I believe, in quite a prominent area of London. So they might want to keep their ears to the ground in terms of how much this license is costing them in comparison to turnover of the business. So perhaps in that scenario, a license is more appropriate.
We talked about flexibility when it comes to licenses and pop-ups. My question, I guess, is we all sort of understand leases in the residential context. Almost everyone has rented before. And when we rent, it's going to be, for a fixed period, usually maybe like 12 months, a month, 6 months. Why in the commercial context, like if you're a creative brand, why would a license maybe be something that you'd be more likely to enter into rather than a lease?
So I think for pop-ups, especially early ones, a license is more attractive because it allows you the flexibility to terminate and bring it to an expiry a lot easier than if you were to enter into a lease. Equally, leases, for example, will have clauses within them about signage, what you can put up, what you can't put up, how to use the space. So for example, if we take a restaurant, for example, on a high street, the restaurant owner will have to think long term about what kind of restaurant they want to be. So are they going to be occupying the entire premises? Are they going to be putting seating outside? If there's going to be seating outside on the pavement, for example, then that comes with a host of other problems. But that would need to be in their lease.
A requirement to have the correct licenses to operate the business that you want to operate
Exactly.
from those premises, right?
Exactly. Whereas I think for a pop-up, by its very nature, it's probably not going to be there forever. So therefore, a license is more attractive to pop-up creatives. Equally, I think that's the nature of a pop-up, isn't it? They want to test the market. They've got a product, they've got a brand, they've got some sort of following online, and now they're going out and physically putting their stamp on it. By, for example, taking out a license or a lease. But I think for pop-ups, a license is more appropriate in terms of the fact that it's an all-inclusive rent as well.
Yeah, everything is,
it's all
you just take the space and then you use it. And I'm thinking about spaces like Box Park and Shoreditch. They have those pop-ups at the bottom. You've got other commercial spaces, you know, and I mentioned that I used to live in Shoreditch, and there were so many different studio spaces that it would be all blank white walls, and then the brand would go in, convert the entire space, paint it, put a bunch of stuff in it, and then return it back to blank white walls. The whole time the brand was there, they're not really having to deal with, like, you know, repair obligations or what other kinds of things come up in commercial leases that you have to be aware of. Like you have to make insurance contributions to the landlord. You know, there's a lot of burden that comes with a lease. Yes, you get the permanence, the security of a physical space for a long time, but a lease is really not something that a brand should just jump into until they're 100% certain they're ready for that. So I was wondering if maybe you could expand on
so
that
I think
as well.
I think, like you said, with a lease there comes a lot of obligations on the tenant side, but also the landlord side as well. Does a landlord want to go on to lease to a brand or a company that's not been tested yet? Because from the landlord's perspective, they also have to think about whether the tenant coming in can actually afford the rent long term, because that's what a lease is. So from both party perspective, not just the tenant, but also the landlord, it would make sense to be able to perhaps initially offer a license. I also think in terms of leases, there's more monetary contribution. Like you said, insurance, service charges potentially, other insurance provisions. So I think for a pop-up, it would make sense to have a license and then follow on for a lease. Once they've actually been able to test the market and actually think about where they're. So for example, a pop-up could open up somewhere in Shoreditch and think, actually, this is not the right area for me. I've tested it out with a line.
Yeah,
my audience are not the audience.
The foot traffic isn't really the customers that we want. And that's a better option to at least try that rather than fully commit
to a long-term lease. Where bringing it to an end is more difficult. I appreciate in leases you have break clauses, but you know, as we'll go on to explore later into this podcast, a lease is, I think bringing a lease, even if you have a break clause, it can still be difficult. There are many hoops you have to jump through before you can exercise your rights under a break clause.
So basically, a license is, you know, permission. It's kind of all encompassing. It's all in. It's
a bit more informal.
Yeah, it's more flexible, more informal. Whereas a lease is a very formal, contractual arrangement with a lot of provisions. It sets out a lot of mutual obligations on both parties, and even to end it, as we'll go on to discuss, it's not as simple as saying, you know, we'll be out in the week. So, on the point, just talking about licenses and leases, we know that there is a difference, but let's talk about how, even if a document says license on the top,
yes,
it might not actually be interpreted that way by the court. So I thought we could talk a little bit about that, so people don't fall into pitfalls of thinking, oh, well, I wrote it up as a license. I only intended my space to be, you know, used flexibly for maybe a year. But lo and behold, the tenant doesn't actually want to leave. They're asserting their right to, you know, how do we avoid situations like that?
So I think let's look at the document itself first. What does it say? If it says it's a license, then that's good. Let's keep continuing to refer to it as a license. But sometimes it can get very blurry because of conduct. So, for example, a license can quickly be blurred into a lease. So So yes, it's all well and good if a license actually states in the document that it's a license. That's the first step. The second step is in conduct of the parties. So, for example, so it can become a lease very quickly if there's exclusive possession, if there's a base rent, if there's a fixed term, for example, then all these three things, or if there's proprietary interest even, then all these things can hint towards a lease, in which case it can be argued potentially that a license, despite it saying license on the top, is actually a lease, and therefore would be accompanied with not just the rights of a lease, but potentially the responsibilities of a lease. So I think what could be the takeaway from this is just because the document says a license does not necessarily mean it will be interpreted as a license. Conduct is very important, and definitely something to be it's something to be penciled out at the very beginning of entering into a license or a lease by parties asking lots of questions
and understanding.
So if I did this, what's this? And I think having legal, and I know as a solicitor saying having legal representation sounds like I'm selling myself. But I truly think that there are more nuances that to consider. So yeah, I think that would be...
It's better they ask you in the first instance than it all goes wrong and then they've got to get me involved. Because we always see everything when it's all got a bit belly up. So putting ourselves in the shoes of a brand, I don't know if you can think of any examples of a brand that has taken itself, maybe entered into a lease or has taken its business. I'm just thinking a lot really we've had a lot of online businesses and online brands. Are there any that you can think of that have actually made the decision to have a physical space and it's worked out for them, or anyone that it didn't work out for?
We've seen the Molly May brand. So she was purely online for a couple of years actually. And I'm not sure if her pop-up has a license or a lease, I'm not sure. But that's a brand that sort of had a really big online following. I mean, we all sort of know who Molly May is and where she started from, and now she's built this huge empire. I know she was a director for another clothing brand as well before having her own, that has now put, a physical footprint in London. So for brands such as the ones from Molly May, or for example Tala, that has recently taken up physical residence in London.
Is it on Carnaby Street, I think?
I think so.
Yeah, I think I saw she opened a second one. So yeah.
Shout out to you. Cool. Yeah, well done to her. There are legal implications to think about prior to entering into a license or a lease. I think both, whilst a lease is informal, potentially more flexible, I think we have to be careful to not give the impression either that you don't have rights or responsibilities that come with a license. The something to think about for these sort of new brands is, how long are we going to be here?
Yeah.
How long does my lease need to be?
Yeah.
And I think what they primarily need to think about is, can they afford the rent? Are they at risk of forfeiture, etc., etc. But I think equally they need to discuss break clauses.
Yeah.
The business might not go how they wish for it to go.
And can they get out in that circumstance?
Yeah, and I'm in no shape or form giving advice about how businesses should be run. But the longevity of your business does determine your break clause that you'd want to exercise in your lease.
And I think as well, everybody wants to have, their name on a sign or their brand's name on a sign, and have like a desk and an office and all of that. But I think especially since we've seen after COVID, even very well-established businesses, companies, with multiple offices, had sitting on empty businesses that they very much have leases that still need to be paid for, but they don't have the workforce physically occupying, or their foot traffic dramatically reduced. So many commercial landlords and tenants really felt that after COVID. And I think, especially with how things can go viral, I think social media, or maybe virality, can also be a false flag for a brand, because just because you're getting millions and millions of views doesn't necessarily mean you should jump headfirst into a 10-year long commercial lease, in prime London. Because, similarly, just because you had one successful pop-up, that doesn't mean it either. Test it, trial it, and then when you can actually see, with your business forecast, we can enter into this lease comfortably. One brand I really like, Kai Collective, they opened an office in Shoreditch, and I've been there for a few pop-up events and brand events they've had. Similarly, they don't have a retail store. They have an office. They've had a few events in the office, and the founder has, said we were able to do this because it really wasn't having that much impact on our cash flow in the round, so we could afford the office. But when it comes to things like their sample sale, that's still a pop-up. So they haven't actually gone the whole hog and taken out a commercial lease for retail premises. Right. And that's, I think, that's a really interesting example, I think, as well, of a business that has thought about it. I know if they had a store, I'd be in there every day, and I would love to see them like on the high street or in Oxford Circus or something like that. But I understand that it's not necessarily the right thing for every brand, and it makes sense, So I do think it is important, especially in the world where a brand can have massive online visibility, just to be careful before you sign on the dotted line. So the next topic I want to talk about was user clauses and planning permission. So, for example, just off the top of my head, let's say I have a retail store and I want to have an activation event in it. I want to have DJ, I want to serve alcohol and all of that stuff. Why might I not just be able to do that straight away?
Well, you need a license. So let's take, for example, a business, chocolate business, who also want to serve coffees and hot chocolates and other pastries and food items to get more people in. They would need a specific food license, so they'd have to apply for and be granted before they can actually start doing that first. If not, then that's in breach. So I think it's definitely worth, whilst you're negotiating the terms of your lease, is to be able to provide your solicitor, or if you don't have one, the landlord or the landlord's representatives, with all the ways that you think or you can imagine you're going to want to use that space. I think this stage, the preliminary stage, is so important.
So pre-contractual discussions, really
important. Because if not, then we would have to get involved. And I think coming from a property disputes background, I always think having to dispute something is far more expensive and costly than if you just ask the right questions at the beginning, which isn't really my area. It's more property transactional lawyers sort of territory. But being on the dispute side, I can see all the ways that it could have gone wrong. So I think it's for the brand or for the commercial tenant, it's just important for them to communicate what exactly it is they want to use it for, and sort of take it from there and make sure you've got all the licenses and planning permissions. So, for example, let's take law firms for an example. Not as exciting as other brands, creatives and whatnot. But let's take a law firm, for example, taking up a commercial office. And this law firm takes up a lease in a commercial office, and they look and they see, we've got access to a garden. This building comes with a lovely garden, clearly intended for use. Perhaps you would think, the garden's free to use, as you would do in any garden. For example, that law firm could host a barbecue, a summer party, for example, for their employees. That's not necessarily the case. The garden could quite specifically just be for sitting and enjoying day to day between certain hours.
Exactly. Not necessarily late night or anything.
Exactly. And I think it depends. So certainly think about the hours you're operating. Are there going to be instances that these brands or companies are going to want to operate outside of the normal working hours, which is 9 to 5, for example?
And if this is probably more relevant in the lease context, but your lease will also, if it's a commercial lease, will probably be to operate a business between the certain hours, and it's a totally different thing.
Yeah, completely different ballpark. And you know, again, this goes back to saying, ask all the right questions. So you know, I think these are things to think about: operating hours, and also where you are. Are you a commercial space surrounded by residential properties?
Because you're going to find issues, and there's you know so many examples of where a venue, maybe, I know venues, they have permission to be a venue, but because they're located in a residential area, or because the area it's located in becomes heavily residential, they actually find that when it comes up to renew their license with the local authority, there's objections. Things can change. So being aware of that is important. Yeah.
I think it's easier to take up a commercial lease if your neighbours are commercial lessees too. For example, near where I live, there's a really good steakhouse, and on their website they advertise that they've got a rooftop. And this a couple of years back, but we went down to have food and we said, can we sit on the rooftop? And they said, oh, we used to be able to do that, but the neighbours complained.
Oh, the noise.
So we can't actually use it anymore.
Oh, what a shame.
And I thought, oh, so that got me thinking. So I know you gave the example at the beginning about when, about can they do this, can they do that? You know, and that got me thinking, I wonder if it's in your lease, like you can actually use the rooftop and what hours, but maybe it's not.
Or it could be subject to appropriate permissions.
Exactly.
Or there will be a covenant not to act in breach of any local authority requirements. Yeah,
exactly. So
there'll be some way of capturing it.
Exactly. Or the steakhouse actually viewed the premises and said, it's got a rooftop. We can put chairs and tables up there. Because they assumed, because why else would it be there?
Right. Which is why coming back to pre-contractual discussions, it's really important. No, that's really helpful. And I think, you know, if you are in a situation where, especially given with creative businesses, you know, cash flow may require you to be creative with your business.
Right.
I think of, I don't think Carhartt does this for money or anything, but they've got cafes in so in the King's Cross Carhartt, it's clothing side, but they also just have a fully functional cafe that they just run out of the shop. I think it's part of the...
That's more popular nowadays.
Yeah.
And I think coffee is the new...
It's a thing, isn't it? It is. And so many brands want to have something like a coffee bar or something like that. And I think being clear as a business, like, okay, what are all the possible routes we could go down to make money for this business or to serve our customer? And can we ensure that we negotiate provisions that give us the option, or at least give us the option to ask for permission not to be unreasonably withheld, which is lawyer speak for don't ask a stupid question and we'll probably say yes. You know, so I do think it's important that businesses think about that. So in a similar vein, let's talk about fit outs and reinstatement, because we know with brands, you know, I could think of Aesop, and I mentioned Carhartt as well. These brands, when you walk into the shop, you are transformed. You've entered into their brand universe. You know, it's not just a white box.
No, so like Hollister.
Yeah, Hollister. Yes, that's a really good example.
You know, if you said to someone, what do you feel when you go into Hollister? Immediately there'll be scent.
Yeah,
there'll be all these screens, like these
with all the models,
right moving screens of models surfing. You know, and
dark as well.
Dark, and
the lighting and everything.
So I guess creatives, you know, from my own experience, creatives such as clothing brands, they want to express their brand. This is their way of marketing, isn't it? So they would want to stick things on that convey that message
and that sell
customers.
I mean, I saw a perfume shop with my husband, and they have this massive suspended upside down bunny rabbit. It's huge, and it's suspended from the ceiling. And, that's obviously,
they're not going to be the bog standard clause.
So you're going to need to ensure that that's something you're allowed to do. So when it comes to this sort of making it beautiful problem that creative tenants have, so they do things like custom murals on the walls, lighting, like we mentioned, and all these types of custom build outs. Why is it important to understand not only are you allowed to do that under the lease, but also the condition of which you have to reinstate the premises to when you leave?
So there normally will be a covenant within a lease, and this is not just for commercial leases, for residential leases too, that however way you design it and decorate it, you have to, essentially when you're giving up vacant possession of the premises, you have to take it back to how you saw it. You have to take it back to how it was before you came in and put your mark on it. I can understand that from the landlord perspective. They don't want to come in. Actually, don't have to come in to take down your murals.
And repaint the walls.
Repaint the walls because there's a cost to that.
Yeah.
So for the commercial tenant coming in, these are things to think about. Is how much signage can I put up? Some leases might say very minimal. You can't put a nail in the wall. You can't change this. You can't change that. And these things. So if we have these clause or provisions, and then they say you can't do X, Y, and Z, there might be an insurance issue. There might be insurance that says.
And there'll always be a provision not to do anything that would void.
Exactly.
The landlord.
Well, that's what I'm trying to get to.
Yeah. Sorry.
Thank you. That's a much more coherent legal way to put it. I hadn't thought. So you have to think about those things, and the tenant isn't necessarily going to think about that. The commercial tenant's going to come in and see the future of the premises, whereas the landlord, from their perspective, is actually, I'd like it.
I'd like to maintain the integrity of my asset as well.
Yeah, but it's easily returned back to the state it was when the commercial tenant came in. So I think it's important. And also, I think for the commercial tenant, they need to think about: am I taking out a lease from a commercial landlord that's had a commercial tenant before? They'll be more accustomed to varying the lease.
On a bit of just a legal geeky point, there's an interesting authority that I think is worth us discussing. So it's Capital Park Leeds and Global Radio Services. It's a 2021 authority from the Court of Appeal. And this was really interesting. So the tenant, which you can imagine from the name, they stripped out the ceilings, the radiators, and all of the lighting. So they basically gutted the place. And they did that all before they exercised the break clause. So they exercise the break clause and they tell the landlord, we're returning the property back for vacant possession, but they didn't reinstate it. They left it gutted as it was. So the landlord, of course, was not happy about this and wanted to essentially say that the break wasn't valid. The tenant's still obligated under the lease. The tenant needs to reinstate the premises back. And what the Court of Appeal held was that the tenant's break was valid because the actual condition in the tenancy only required vacant possession, not reinstatement. And so the damages for the loss of reinstatement were a totally separate claim.
Exactly.
The tenant was not prevented from
exercising their break clause
and exiting, even though that they'd left it all in that state. So it's not that the tenant had no liability whatsoever for causing damage. Of course, the landlord's always going to be entitled to seek damages as a remedy. But in this type of situation, a landlord in the same space needs to really ensure that reinstatement, if you are going to be leasing to tenants who are going to make substantial changes, like a radio company, they're going to need to custom fit out the building. If you at any point, it's not just good enough, saying you can terminate the lease. You need to be very specific. Only when the property has been reinstated to X condition, then you can run off into the sunset. And I think the problem with the landlord here is that they would have to deal with the issue in a separate action, whereas had they ensured that the lease provisions, were a bit more all-encompassing, it would have been a bit more cost-effective and straightforward for them to deal with and say, well, no, clearly you haven't fixed it back to how it needs to be. So
I think the interesting thing about this case as well is making sure that when drafting the lease or entering into a lease, the clause that governs the break clause matches up and is not in contrast with the yield up clause. These two should mirror each other. So for example, the break clause in these scenarios should say you can exercise your break, you can exercise this break clause X, Y, and Z subject to clause, for example, 10.7
having been adhered to,
having been adhered to, and 10.7 should be the yield up clause within the lease. Again, this is I know we're talking about commercial tenants here, but this also does apply to residential leases as well. So I think this was the point in which the appeal court actually, I think they made a very specific comment about how these two clauses should actually be drafted with both of them in mind and to be read in conjunction. Yeah, they should be read in conjunction to one another. It's interesting because they also said, like you mentioned, they did say the landlord had could seek remedy by way of damages for breach of covenants in the lease, which is great that they have on the route, of course. But I think that's a separate claim, separate cost, separate legal fees now. So I think I think this is something to be careful of. I mean, the scenario, it benefited the
the tenants are right.
You know, it benefited the.
Which is also why it's good as tenants to know what's in your agreements, because there may be things that might work for you in there. You never know.
But I think also it's worth mentioning that you should get your report. You get, for example, if you're taking a report on title, you get normally, which would explain a lot of the clauses and what they mean to commercial tenants. And so my advice would be to make sure you put a lot of emphasis on this report on title, and if there's anything you don't understand. So a report title will normally be drafted by the transactional lawyers. But if you don't understand anything in there, definitely ask questions from it. But again, I mean, it sounds like I'm selling my job here. I'm not.
Well, no,
I don't draft leases.
I don't think it's controversial that legal advice is very important, and especially if you're a creative business owner, founder, brand, your skill set is not necessarily in reading boring black and white letter provisions of contract. And that's what we're here for. If your business can afford a pop-up, if your business can afford to enter into a commercial lease,
they can afford legal.
You can afford legal fees.
And like I said, I don't draft the leases. That's more transactional lawyers. But I think that their role is so paramount to what we're talking about now. Whereas I would only really, really get involved if something's gone wrong. So
if everything's done well, you won't see us.
If it's done really, really, really well and everyone gets on,
like we will just be quiet.
We're not going to be involved.
So moving on slightly from the physical things like physical use of the space or changes to the space, let's talk about some of the reputational and operational risks for commercial landlords renting to creative tenants. What I'm thinking about is the high-risk tenant behavior. So you've got your obvious things like unlicensed events, late night parties and stuff. You've got damage, you've got insurance concerns. But I wanted to talk about circumstances where you may have, for example, a tenant that represents that they want to use the space in one way, but they actually use it in another. I'm talking about interesting cases that I'm aware of things like cannabis cafes, for example. A landlord innocently believes that maybe the tenant that they're renting to is just going to be using it, for whatever reason, but they may have a shop front in the front, but in the back, they have a whole different situation going on. Or another example of a commercial landlord who wasn't aware that his premises were being used as an unlicensed sex shop, and he ended up still receiving the fine. For landlords that find themselves in this situation, I think the issue is really the risks not only for their reputation, let's say with the local authority with regards to future license applications, but also generally, especially based on where the commercial premises is located, you don't necessarily want to fall out with your neighbors, because as you mentioned before, it's easier to be a commercial landlord in a space where there's other commercial premises as well. So if you're a landlord and you want to, lease to maybe a more creative type of tenant, what kind of things can you do to prevent ending up in a situation where you're suffering reputational risk, or your actual operation of renting out commercial premises is at jeopardy because of the nature of the tenants you've taken on?
So I think this is when we come back to making sure that the covenants in the lease are drafted with that in mind. So for example, the landlord could stipulate to say the premises will not be used as anything other than the intended nature of the business. So for example, let's say it's a coffee shop. So make it as specific as possible. When at the point of drafting, the landlord would have a remedy if there's a breach of covenant, obviously within the lease, but I think we'll get onto that later. But I think just be very specific. I think not just commercial leases, but for example, on my house title deeds, because the house is really old, it says it's not to be, I can't erect a shed. I can't have sort of a pub at my back garden.
Oh, what a shame.
I know.
There goes your pub idea.
I know. I'm missing out. And all these covenants that still, well, in residential situations they run with the land. But all of these things you need to be careful of. I mean, not that I'm intending to erect a pub in my back garden, but
if you were, you couldn't.
Right, I couldn't, exactly. And this is a freehold title.
Yeah.
So regardless, I think you need to be careful of, what I'm trying to say is my covenants within my title is quite specific to what I can and can't do in my back garden. So I think within a commercial lease, just make sure that it's strictly for the use of what the tenant has told you to be. Because if they then use it for anything else, then you have the right of forfeiture.
Yeah, which we'll get on to. And it's also important for landlords to do their due diligence, because especially if a business is new, it's a startup, or they don't have an established record, renting from anyone. Yes, you'll always have, personal guarantees and things like that. But if somebody is already a slightly nefarious character, the business is a front for something else. Even if you've got personal guarantees and you're trying to enforce them, it may not work. It's just
to be careful.
Be careful. Do your due diligence. The same way in residential context, you have to prove the right to rent. I think commercial landlords should also consider being diligent with who they rent to. I know that things are changing in terms of company directors having to prove their identity and stuff like that to Companies House. So there is a general move in the commercial space for more accountability and transparency behind who is behind it, and more security. But don't be afraid as a landlord to ask for references. Don't be afraid as a landlord to, maybe you want to meet before, meet face to face and, get an understanding of the business. You protect your asset. It's worthwhile to do maybe be a bit extra at the beginning, then find yourself holding the baby, local authorities breathing down your neck. They want to know, what did you do to be aware of the situation, because you can't just put your hands up. And that's where the gentleman who was fined for the unlicensed sex shop, he got in trouble because they said, well, it wasn't simply enough for you to bury your head in the sand and not look. You have responsibilities.
I mean, that's illegal. That's I think it's in that sense, I would presume he had the right to forfeiture.
Yes, and so really what I think it's important to be aware of is that don't assume that because you're a commercial tenant that you have the same sort of security as a residential tenant. Because a residential tenant could go months and months without paying the rent. Yes, of course, the landlord's entitled after 2 months, if it's an assured short hold tenancy, or the landlord has various other types of remedies, but the landlord still has to work through the court process.
Sure.
So it's not an immediate thing.
It's not an immediate thing.
Exactly. Yeah. So whereas in the commercial context, by the very nature of it being a commercial asset, the law is set up in a way that a landlord that's being basically left out of pocket by a tenant that's not paying rent can quite swiftly get their property back.
Possession.
And the same goes with breaches of covenant under commercial leases. You know, don't think that you can do whatever you want and the landlord's not going to enforce their rights. Of course, it's better for the landlord most of the time to maintain the commercial relationship. They'll try and work through it. But if the landlord believes that this is a breach that's not capable of remedy, be aware that forfeiture is a realistic prospect that's on the cards.
Yeah, and I think it's also, you know, they have to think about how that impacts their business. So as a commercial tenant, you're obviously running some sort of business, whether it's a clothing brand or a law firm or really, it doesn't really matter. But you have to think about the longevity of your business as well, and just be wary that, you know, forfeiture can happen, and that you know that there will be a clause explaining how and on what terms forfeiture can occur. And so I think it's. I mean, it's a bog standard clause in any lease, really.
And it's always
advised on it.
Yeah, you should be advised on it. And I mean, I've seen it. I've had one venue I loved in Shoreditch. It was this amazing hip hop bar. They'd renovated the whole thing. It was really nice. They had a pub downstairs as well. And, you know, really, really nice venue. Unfortunately, there was an event one evening, got a bit out of hand. And I think there was a physical assault. And it was just such a shame because they were there one day and then I came back and I just saw the notice of forfeiture and re-entry on the door. And I was like, oh, another one bites the dust. But that's just the reality. So protect your business as well, because as well, if customers come to associate you with a certain location or, you know, you don't want to just
give up the premises.
Yeah, you know,
have the premises taken.
Yeah, so be aware, creative tenants, that there are rules and there are consequences, and the consequences in the commercial context can be quite swift and quite severe. For sure.
100%. I think, and also I think with forfeiture, it can come about very quickly. And I think going back to costs, you know, again, you're going to have to get yourself involved potentially with solicitors or barristers or what have you, with lawyers, and there'll be costs associated with that. So definitely something to think about. But I think this goes back to making sure both parties entering into the lease are fully aware of their obligations. And just sort of, I think my advice is just stick to it.
Yeah, just follow the rules. Yeah, lawyer says follow the rules. Revolutionary.
I'm reinventing the wheel here.
So to summarize some of the key takeaways from this episode, check if it's a lease or a license before you enter into it, and really think about what your business needs. And also, if you're a commercial landlord, really think about the way you intend to use your space, because the difference decides everything. And the document isn't the end of it. Conduct of the parties is also important. So if you call it a lease, if you call it a license, the conduct of the parties is very important. So if you call it a license, but for all intents and purposes, it's treated like a lease, don't be surprised if the court interprets it that way. Don't assume that your creative use is automatically allowed either. Be aware that there will be provisions around use of the premises and planning permission, and all of that matters. When you think about making the space your own, also be aware about relevant provisions in relations to fit-outs and reinstatements. You might have to give the property back in the exact same condition as you found it. So it's better to be upfront with the landlord and figure out what's allowed at the beginning. And protect your brand's reputation, and also protect your reputation as a commercial landlord. The wrong type of tenant can undo maybe years of goodwill that you've built, and can also put you at risk for future local authority license applications, for example. And if you're a creative tenant, you don't want bad references either. Be aware, especially if you are subletting the premises or allowing other people to use the premises under your lease. Be aware of what they're doing and avoid getting yourself in any sticky situations. Okay, Anna, some quick fire questions before we wrap up. So what's one clause that every creative tenant should understand?
Break clauses.
Okay, cool. And what's one mistake that commercial landlords keep making in this context?
Not enough due diligence prior to granting a lease.
Okay. Yeah. What's one practical tip for understanding the terms in your commercial lease?
Asking lots of questions.
I could. And getting a lawyer.
I was going to say that, but it just sounds like I'm trying to sell myself.
So that's it for today's episode of The Ground Floor. A huge thank you to Anna for joining me and unpacking what really happens behind creative use of commercial spaces. If you're a creator, a landlord, or just someone who's built something beautiful in a borrowed space, remember it's always important to understand the provisions of your lease or your license to protect your creativity and also your contractual position. I'm Blessing Makosha Park, and this is The Ground Floor. Stay tuned for next time, where I'll be joined by Professor Martin Dixon to talk about what really happens when friends buy a property together and why the law may not see your friendship in the same way that you do. I'll see you in that episode.